Weeks, 7 weeks, 8 weeks. Well, Court TV's Savannah Guthrie has been inside the courthouse. She's just come out to report to us about some scheduling news. Savannah, what is the latest?
Well, who's counting, Lisa? We are. We are counting. Let me tell you what was just said at the end of court today. The defense confirmed that Chris Tucker, who's on the stand right now, is their last witness. Tom Sneddon and the DA said he has some witnesses ready to go tomorrow for the state's rebuttal case, but he didn't think enough to fill a whole day because of just scheduling issues. They have to come up from Los Angeles. But he told the judge, I do expect to be done with my rebuttal case on Thursday. So at that point, it's either all the evidence is in. Of course, the defense would have a chance to do a SIR rebuttal if it so chose, but we don't know what the story is on that. So we are very, very near to the end of this case.
Well, Savannah, you buried the lead. If the defense is resting with Chris Tucker, didn't they forget someone? Didn't they forget to call an important witness who knows a lot about all the allegations in this case? Who am I thinking of?
Oh, Lisa. Who could that be? I'm thinking of somebody, Lisa. Yes, evidently Michael Jackson will not be taking the stand. You're right. I did bury the lead.
Michael
Jackson will not testify in this case.
is not testifying, and I think we are now confirming that. Ed Sapone, the jury is going to be instructed in this case, as they are in every case in the United States when a defendant doesn't testify, that they are not to consider that. Let me go out to you.
Oh, Lisa.
You love that, huh? That was just for you, Savannah.
Whatever.
Give us the high points of his testimony. I understand there was an issue of the accuser asking him for money.
Well, that's true. You know, it really struck me that this is the first testimony we've really heard where it's the accuser making the repeated calls to the celebrity and asking for money. And that's what Chris Tucker told the jurors today. He said that after that first benefit, it was the accuser who called him and said, you know, we didn't make any money. And that Chris Tucker decided to wire about $1,500 to the family. And then he said he received numerous calls from the accuser over the next, weeks and months and during the course of their relationship. It was interesting because the jury was just enraptured with Chris Tucker and really kind of followed him into the room. And, it was a big celebrity day here. I don't have to tell you, not just you as a comedian, Lisa Bloom, but also Jay Leno was here. And at the end of his testimony today, he said, I just want to tell everyone, Renee Zellweger's the guest on the show. And Diane's been doing a little reporting, and she found out by coincidence that Lisa Marie Presley is the musical guest tonight.
No kidding.
We don't make it up.
Yeah,
just by coincidence.
Hey, Diane, I've been thinking a lot about all of the testimony that the defense has presented about the accuser's family asking for money. There was a time period when he had cancer and the family was told he was going to die. If the chemo didn't get him, the cancer would. And then he recovered from cancer, thank God. My question to you is, all of the times that they were asking for people for money, or they weren't asking, but people were just giving them money, was that during the time period that he had cancer?
Yes, much of it was. I think if not all of it, I think all of it was during the time period, and you have to remember, his father stopped working to be at his son's side. He took like a leave of absence, was getting no money, and the only money coming into the house was because the mother was working. She was working as a waitress. So, if the greatest sin of this family is that they are poor, then that probably shouldn't be held against them.
Well, right. Now, when did he recover? When was he told that he had recovered from cancer? Roughly.
Well, he got cancer in 2000. In 2001, he became terribly ill and almost died. And I think it was by the end of 2001 into 2002, he was well enough then to go back to Neverland in the spring for a birthday party with Chris Tucker and his little boy.
And Ed Sapone, let me go to you. If I'm the prosecution, I'm making a timeline and hitting hard on that point that, of course, this poor family was asking for money. Then once he recovered, no more requests for money, no more getting gifts of money. And it's 2003 that he makes these accusations and he never asks for a dime.
Yeah, but that's not the only time this mother has asked for money. She lied and collected welfare when she had a $150,000 settlement, and it's never ending with this mother. It's not just that time period.
That's true. All right, Ed Sapone, we're going to have to leave it right there. A big thank you to all of my guests in New York, psychologist and author Anne Renee Testa, as well as criminal defense attorney Ed Sapone. We will fight another day, Ed. And in Santa Maria, Court TV's Diane Diamond and Savannah Guthrie, our eyes and ears in the courtroom. Thank you so much. I'm Lisa Bloom. Nancy Grace will be back here at 3 o'clock tomorrow, but you can catch her tonight on CNN. I will see you tomorrow at 5 p.m. Eastern right here to wrap up the courtroom day with you. I don't think Jay Leno was threatened by any of my terrible jokes. Until then, have a terrific evening. Good night.
No comments.
Previously on NYPD Blue.
Also called to the stand was Tonight Show host Jay Leno, who may not have given the defense the boost it was hoping for. We're going to have a live report for you in just a moment. Also today, we're live in Florida for the trial of 2 pilots accused of operating an aircraft while intoxicated. We'll have the latest on that case at 11:30 Eastern Time. But right now, let's go to Court TV's Savannah Guthrie, who's standing by outside the Santa Maria, California courthouse. Well, light at the end of the tunnel, Savannah. Can it be? Can it be? Do we really expect the defense to end its case?
Yes, light at the end of the tunnel, and it's not my raincoat, Jamie. It's true, the defense is supposed to rest today. They said that they called their last witness. It's Chris Tucker. He's still on the stand, and I think he probably has a couple of hours on the stand left. But then, that's it for the defense, and the rebuttal case for the state will start straight away.
Chris Tucker, an interesting choice for your last witness. What's the significance of this witness? We've heard a little bit from him already. We'll hear some more today. But why finish this way? What does the defense hope to get out of Chris Tucker for the Michael Jackson side of this case?
Well, presumably the defense thinks Chris Tucker has something to say that benefits them, and I also think that they're, relying on a little bit of star power. I think that holds some sway with the defense. So far, what's important about Chris Tucker, I think, is he's the first witness to really say that the accuser himself called and asked for money. Let me read you a portion of his very brief testimony. We only had him on the stand about 20 minutes yesterday. It started like this. The question was, so John Doe told you they didn't make a dime at that fundraiser. This is the fundraiser at the Laugh Factory. Answer, yeah, they said they didn't make any money and they needed some money. And you then wired them some money. Answer, yeah, I wired them some money. Question, how much did you send them? Do you know? Answer, it was probably $1,500 or more. Okay, and you believe that was for medical expenses? Yes, well, I was hoping it was for that. This witness also said that John Doe repeatedly called him on the telephone during the course of their relationship. And, we're starting to see kind of an MO on the part of this family. One thing is that the accuser's mother rarely asks directly for money. She often, it would seem from the witnesses, will just sort of talk about her plight and kind of engender people's sympathy, and then they think of their own volition. They start to give her money, and then sometimes the kids call. One of the witnesses last week, Renee Watson, said the accuser's sister called her all the time, and now we're hearing from Chris Tucker, excuse me, it was Aja Pryor, and now we're hearing from Chris Tucker that it's the accuser himself that was constantly on the phone with him.
Well, Savannah is going to stay with us, of course, throughout our special, but I want to take an opportunity to dissect Welcome back to Trial Heat and our special report on the Michael Jackson case. I'm Jamie Floyd, and we go back out to Savannah Guthrie, who is in front of that Santa Maria courthouse, waiting, as we all are, for Michael Jackson to arrive for what we expect to be the last day of his defense case. Savannah, yesterday, so many witnesses on the stand. Hard to keep them all straight. I have Jay Leno on the brain, so let's go back to that witness. A lot of anticipation for Jay Leno because we heard about him from the very beginning of this case. So he ultimately did take the stand. What exactly did he tell the jury? And in keeping with Bill's answer earlier, Bill Bastone's answer, did it help the defense or did it hurt the defense?
I don't think it hurt the defense, but I don't think it was the slam dunk that we all thought it was going to be based on what Tom Mesereau promised in his opening statement. But no, I don't think it hurt the defense. Basically what he says is the accuser left him several messages. At one point he called the accuser back in the hospital room and spoke to him, but as Bill says, he of his own volition, Jay Leno said, I think he was kind of groggy. He said that a couple of times, setting up a prosecution argument for why the boy might not have remembered speaking to Jay Leno. And basically the most powerful thing Leno said for the defense was that the accuser seemed a little scripted, seemed seemed a little rehearsed in those messages, was overly effusive. Those are Leno's words. He's saying, oh, I love you, you're the greatest. And Leno said, you know, he speaks to a lot of kids, and that just was not the kind of demeanor most children have. He said most children, it's kind of like pulling teeth to get them to express anything. He sort of mimicked a child's voice and said, yeah, you know, most kids I talk to are like, oh, hey. Yeah, hey, how are you? And here's a kid who's using all these flowery words to say how much he loves him. And that kind of, you know, caused Jay Leno to raise his eyebrows a little bit. But that was about all he said. He didn't really hurt the prosecution too bad. And in fact, he said, you know, they never asked me for money. I'm sure of it.
And he did get on the stand and off the stand awfully quickly. I noticed that. Michael Jackson, of course, arriving now. We've spent a lot of time, Savannah, talking about the interaction between Michael Jackson and various witnesses as they took the witness stand, the more obvious one being the accuser. What about with Jay Leno? Any recognition, any eye contact, anything of any sort to suggest a good or a bad relationship on the part of these two very famous men?
You know, Michael Jackson, believe it or not, does not betray a lot of emotion in this case, but there was obviously a lot of energy when Jay Leno came into the room, and, you know, the jurors all had their eyes on him, and he really glad-handed the court officers on his way in. On the way out, he stopped and looked at the sketch artist sketch of himself and said, oh, not bad, you know. So he definitely had that celebrity charisma in the room. You know, for one time in this courtroom, we may have had a bigger celebrity even than Michael Jackson in that courtroom.
Now, I'm no doctor, but Michael Jackson is looking a little worse for wear today, I must say. I guess a trial like this would take a toll on any defendant, guilty or not. Savannah, you were talking about Jay Leno not being the slam dunk witness they had hoped for, but there were other witnesses yesterday, and as you reported earlier, 12 of them. There was one who may have been a better witness than Jay Leno, a woman named Mary Holzer. Who was she, and how did she help the defense?
You know, I think this witness is pretty explosive for the defense. She's the paralegal who worked at the law firm that represented Jane Doe, the accuser's mother, in her litigation against J.C. Penney. She told a lot of stories about Jane Doe that weren't particularly flattering. Most importantly, she said that Jane Doe admitted to her that the injuries that the mother had claimed came from J.C. Penney's security guards actually came from a beating from her husband. So she basically puts the lie in Jane Doe's mouth, that she made that allegation and that it was a false allegation in a prior lawsuit. That's bad stuff. And then the second thing she did was say that at a psychiatric examination that Jane Doe had brought her children to as part of the lawsuit, that Jane Doe was very reluctant to let her children answer just routine psychological questions, and that Jane Doe made the following statement: you know, I'm pretty sure that John Doe, her son, the accuser here, will get it right, but I'm not sure that his younger brother will be able to remember what we practiced. It's really the first direct evidence of Jane Doe coaching her children to lie in a lawsuit. And I don't have to tell you, Jamie, that is the defense theory of the case.
Well, and as we've said, they've done a very good job of calling into question the credibility of the accuser's mother. But let me ask you, Stephen Skirka, yes, what does that have to do with the...
Well, all paths lead to the mother. That's the defense theory, including the molestation allegation by the accuser. It's linked to the mother because she's the one who's coaching the boy to make the accusation. So she's an integral part of it, and you see the prosecution, Jamie, has played into that by calling her as a witness, making her a part of the case. They've said she's important. It isn't the defense that's made her important, the prosecution has. And the defense is saying, all right, she's that critical, let's just find out what this person's made of. And you see what you're going to find, interestingly enough, is that the prosecution's going to be doing a lot of backtracking in their closing address, saying, well, you know, she's really not that crucial to our case, and, you know, there may be some problems with her credibility, but look at the accuser. But I don't think that they can do it that neatly and cut and dry.
Bill Bastone, as we look ahead to the closing arguments, which won't be too far in the distant future, what about that closing? How does the prosecution deal with the mother? You've covered this now for SmokingGun.com as its editor well before the trial even began. The mother has continued to be a central figure throughout, but can the prosecution really distance itself from the mother when they get up to make their rebuttal case and ultimately their closing argument?
Well, I'm sure they would like to. I mean, she pretty much speaks to the conspiracy count in the indictment. Obviously, the other 9 counts hinge upon her 2 boys. So, I mean, I don't think that they're obviously going to dwell on her to the extent that she figured in the trial in chief, but I mean, they can't avoid her, though I'm sure they would love to, because I think that she was a disaster. I mean, I think there was one other interesting thing yesterday from the lawyer who represented her in the J.C. Penney case, and he talked about having met with her 25 times prior to her being deposed in that case. And it was at that deposition for the first time that she mentioned that during the J.C. Penney's incident, she had been fondled 25 times. And he had met with her 24 times, and she never brought this up prior to this deposition, and then she went off in great details about what that fondling entailed. So I think it was another instance yesterday where kind of, you know, I think the defense wants a juror to think that John Doe and Jane Doe are kind of a joint entry, and that you should consider, you know, the shortcomings of the mother as the shortcomings of the son. We'll see whether that flies or not.
Well, yes, Jane Doe definitely the wild card in the Jackson case from the point of view of both defense and prosecutors. Now that we expect the defense to rest, Michael Jackson, it seems, won't be taking the stand, and that back out to Savannah Guthrie and talk a little bit about race in this case. Oddly enough, in almost every courtroom in the country, race becomes an issue in this country, but in this case, it hasn't been as much so. However, it has reared its head on and off. Tell us a little bit about how it might factor in to the case against Michael Jackson.
Well, you're right. I don't think race has been a dramatic factor in this case. But, you know, yesterday we had some testimony that sort of started to get into that a little bit. 2 witnesses, one named Arlene Kennedy, the other one named Leslie Rags, took the stand. And they both were, one of them owns a dance school in Los Angeles, the other one works there. And they testified essentially that Jane Doe asked them for free dance lessons, saying that they couldn't afford it to pay for the lessons. But they also made an interesting comment. By the way, that's Chris Tucker going into the courtroom, getting ready to do his testimony, finish out as per the defense. But anyway, back to what I was saying. These witnesses said that Jane Doe told them about the J.C. Penney litigation and told them that the security guards who allegedly beat her were African American. And they both attributed a similar comment to Jane Doe, which was, in effect, boy, I sure hope my kids don't grow up to hate black people. The other witness said, she said something like, oh, now my kids are afraid of black people. They're scared of black people. And that just kind of hung in the room. I mean, you know, everything has been said about this mother, but we hadn't yet heard a racist comment attributed to her, but there you go, now we have.
Any African Americans on the jury, Savannah? I know that we have a Latino presence on the jury, but Santa Maria, I'm not sure what the African American population is out there. My anecdotal understanding is that it's somewhat limited. What's the composition of this jury?
It's very low, and there's one African-American young man who is an alternate, but that's the only African-American on the jury.
Not that others might not find the comment somewhat offensive, if indeed it was made. We are getting ready to hear a rebuttal case by prosecutors once Chris Tucker, and we did just see him enter that courtroom, once he's finished testifying, we expect the defense will rest and prosecutors will begin their rebuttal to the extent they can. They're not entirely ready, but
which was that they would hear from Michael Jackson taking the stand. There was an expectation in everyone's mind, including the juries, that they'd hear from him. And I think just as he didn't deliver on the promise with Jay Leno, he didn't deliver with Jackson as well.
All right, and as we see Michael Jackson go back into that courtroom very quickly, Savannah, when do we expect the prosecution rebuttal to begin?
I think later today. I would guess Chris Tucker's got a couple more hours on the stand, maybe 3 hours, and then the prosecution's ready with some witnesses, although they don't think that they'll be able to go the full day. Tomorrow, they say, will be a full day, so I think the rebuttal will probably be complete by tomorrow afternoon.
All right, well, that is going to end this Jackson special. We will have another at 12:30. I want to say thank you to the earlier comments on this broadcast and elsewhere that whatever Michael Jackson's proclivities, he didn't seem particularly interested in this boy or in this family, and that perhaps this family is, as the defense suggests, a family of grifters.
Well, I think the general conclusion about the family and the mind of the public is that this is a dysfunctional family, and that was never in doubt. But it's not the family who's on trial, Jamie. We continually put the family on trial as if they're the ones who have to answer for their behavior. It was Michael Jackson who told the world, I share a bed with children. It was Michael Jackson who had 93 allegations against him. You know, for Chris Tucker to come along and say that a little 15-year-old boy is manipulative, yes, I mean, teenagers can be manipulative, but by and large, Hollywood celebrities who are running around taking kids on their jets to help another Hollywood celebrity, that's slightly manipulative as well. I mean, Chris Tucker has nothing better to do with his time.
And there is some question about whether or not ending with a celebrity is a good strategy, but I did hear you say that with regard to your knowledge, your personal knowledge of the interaction between this accuser and Michael Jackson, that at least as far as you could see, there was no particular interest in this young boy, though there may have been with others.
No, correct. As I've consistently said, Michael showed a profound disinterest in the boy and seemed to use him only when he needed him, that Michael used him cynically as almost a propaganda PR tool. And that's been one of the main questions since the beginning of the trial. A, why would Michael have molested a boy that there was no obsession with, unlike the '93 stuff where this kid was traveling with Michael around the world? And secondly, more importantly, why would he choose to molest him after the Martin Bashir documentary had already aired when the whole world was scrutinizing him? But at the same time, the reason why this even went to trial, let's remember, Jamie, is the devastating admission on the part of Michael Jackson, from which he has still not climbed down, which he has still not repudiated, that there is nothing wrong with sharing a bed with children. What we need to see is that Michael finally gets it. Will that happen before this trial is over? We know that Michael's probably not going to testify, but will Thomas Messerow stand up and say in his name, my client repudiates everything he said, he will never do this again, so at least the jury can feel comfortable that if they do let him off the hook, that he's not going to be in court next year?
Oh, I wouldn't hold my breath waiting for that closing argument, Rabbi, but we're going to talk more about it. Michael Jackson not likely to take the stand. We do expect the defense to rest today. It's time for a quick break. Stay with us. Our special report on Michael Jackson's case continues with the latest from Savannah Guthrie and our guests. We'll be right back. Who is in front of that Santa Maria courthouse. Chris Tucker inside on the witness stand, and he's talked about a trip to Miami, but he also talked about a trip to Las Vegas. What did he have to say about that?
That's right. Actually, well before they really even knew Michael Jackson, Chris Tucker had befriended this family, and he invited them to Las Vegas, where he was filming a movie, and thought they were just going to stay for a few days and be on the set. He says, as it turned out, the family stayed for weeks, and apparently the boys in particular were just terrors on the set. He said, we couldn't even, at some points, we couldn't really even film, and he said, you know, I felt sorry for the accuser because I knew he had cancer, and so I was kind of letting things go by and giving them the benefit of the doubt. But apparently, like, the director of the movie and some of his assistants and the people around him were saying, this family is taking advantage of you. In particular, his own brother said this family was trying to move into your hotel, they want to move into your room, and in retrospect, Chris Tucker looked at this as one of the things that started to make him very suspicious of this family.
But not before, Savannah, he offered to give them a car?
Well, yes. He said that he did make this offer because the accuser was complaining about how they didn't have any transportation, and so he made an offer to give them his truck, his old truck, and he even went so far as giving the keys to the accuser's mother. But then he said as he became more suspicious, he didn't want to do it. Particularly the mother really set him, you know, at unease because she was just so effusive and saying, oh, you're like our brother. The whole family was always like, oh, you're our brother, you're like family to us. And so he didn't give the key, he didn't end up giving the car to them. But he said the accuser in particular called him repeatedly trying to get that truck, hounding him about that truck, and he said on the stand it was starting to get on his nerves. And we already know that his old girlfriend, Asha Pryor, said the same thing, that the family was consistently calling him, where's the truck, where's the truck, where's the truck? But he had second thoughts and decided not to give it to them.
I got friends who are giving me cars and taking me on trips to Brazil. Let me ask you this question, Savannah. He became suspicious. At some point, he must have terminated the relationship because here he is in court testifying for Michael Jackson. What was his final interaction with this family, if you know?
Well, you know, this is interesting. I think things sort of fizzled out after February, March 2003, after that trip to Miami where he gave that warning to Michael Jackson about the family because they were hounding him about the car. I think he just started to try to distance himself. But he said right before his testimony was over on direct, he said that he was going through some old numbers about a year ago and ended up calling the accuser. I don't know at which number. And he said, the accuser said, "Oh, hi, Chris." And then Chris Tucker said he heard a voice in the background, a female voice saying, kind of hissing, "Get off that phone right now." And he sort of channeled this voice in the courtroom for the jurors. And he said he believed it was the accuser's mother in the background.
Wow. Well, I got to say, Chris Tucker sounds as though he is a powerful witness, but there is still had a number of comedians in and out of that courtroom. What about Jay Leno in that courtroom? I know you have a bit of an opinion on that.
Well, first of all, let me just say that Canadians always seem to have a problem with any kind of American authority. So immediately, immediately it's the prosecutor is wicked and evil.
I have a problem with authority too.
Oh, so do I. But it's just that I don't have a problem only with American authority. But Jamie, of course this is a morality story. This is a story about the corruption of celebrity, pure and simple. I've said many times I don't think Michael's a molester, but the fact that Michael's been allowed to get away with this, the fact that for the longest time Chris Tucker is telling us, I started getting suspicious. Oh, you mean you didn't get suspicious when your superstar friend called you and said, Chris, will you start flying a family around the world for me? That only when the kids started misbehaving you got suspicious? The fact is that our Hollywood celebrities are corrupt, unfortunately. They manipulate us. Michael, instead of people saying to him, get the kid out of your bed, and Michael, grow up and start behaving like a spoiled brat. You can't do whatever you want just because you're famous. Instead, his friends indulge him. Sure, I'll take my jet and fly this family around to get you out of hot water, which you only got into because you shouldn't have been behind closed doors with another kid's boy in the first place. Jay Leno goes to testify yesterday, and at the end of the testimony, he says, hey, tonight we have Renee Zellweger, and everybody laughs. This isn't a joke. I hope a kid wasn't molested. I hope Michael's innocent, because I hope that no kid was molested. But this is the wheels of justice. This is a trial. What do celebrities think they can get away with? Well, Jay Leno then went on his show, and I watched it last night and told 1,000 jokes about it. By the way, come on, there was no reason for him to even have been a witness. He said almost nothing. The family called him. They didn't ask for money. It was innocuous. It was just another way of Michael's defense reminding the jury of, come on, do you know who this guy is? This is Michael Jackson we're talking about. This is a morality tale. It's about the corruption of celebrity. And the Canadians should stop being so impressed with our celebrities. They're not impressive people, to be perfectly honest.
I've got both Savannah. Shmuley, you always do this. My guest and Savannah Guthrie are trying to jump in. Savannah, what do you got to say?
I just wanted to send your guest into further outrage by telling him that the judge actually made a joke about Jay Leno's monologue this morning. Part of that monologue last night, Jay Leno said, oh, I took a souvenir from my time in Santa Maria, and he showed a gavel. The gavel. Well, this morning before, yeah, the gavel from the judge. And this morning before court got underway, the jury was there, the judge said, has anybody seen my gavel? And the whole courtroom erupted in laughter. But I know I was laughing too, but I have to tell you, I wondered, are the jurors watching Leno?
You know, it is deeply troubling because, as I've said, even in our other case that we're covering out of Miami, the pilot's trial, there seems to be a lack of respect for our criminal courts and criminal process. And I have great respect for any judge in this country, including Judge Melville, but I don't know about joking about it, Steven Skirka, in the courtroom.
Welcome back to Closing Arguments. I'm Nancy Grace. Thank you for being with us. Let's go straight out to Diane Diamond. She's standing by at the Santa Maria Courthouse. Hello, friend. Bring me up to date. Welcome back to Closing Arguments. I'm Nancy Grace. Thank you for being with us. Let's go straight out to Diane Diamond. She's standing by at the Santa Maria Courthouse. Hello, friend. Bring me up to date.
Well, the defense rested today, and there was no Michael Jackson testimony, of course. And then right away, Nancy, the state rebuttal case began. We've had 4 witnesses so far, you know, just like what happens in a rebuttal case, the state is now striking out, or hoping to strike out in the jury's mind, some of the things that they heard during the defense case. They had 2 people on. Shane Meredith used to be a security guard there, and Jesus Salas used to be the manager, the house manager of Neverland Neverland Ranch. They both came up to rebut, impeach testimony that defense witnesses had given about the two Doe brothers being so disruptive that they actually got into Michael Jackson cars and tried to drive them off the Neverland Ranch. Both of these men said, you know, we worked in security, we worked in the house. It's a, you know, small enough staff that we certainly would have heard of this, and we never ever heard of it at all. But Jesus Salas had more impeachment testimony to give. He said, contrary to reports, he never had any money stolen out of his kitchen office. He said that yes, he had seen Michael Jackson intoxicated in the February-March period of 2003. How many times? He said quite a few times. In the presence of his own children. Yes, he said in the presence of his own children. Did you worry that he couldn't responsibly care for them? And he thought for a moment and he said, yes, I felt that it wasn't safe for the kids to be with them. Now, Tom Mesereau tried to rehabilitate on that. He said, you know, every time you saw Michael Jackson, and he happened to have been drinking, there was a nanny with the children, right? And he said, well, that's right, except for, quote, when Michael took them to his room, then they were all alone. You know how this is, Nancy. Rebuttal testimony, it's going to be up to the jury. Who are they believing? Were these boys so disruptive that they had to keep them on the ranch with a sign there for fear that they drive the vehicles out? Or maybe that just didn't happen at all.
You know, Diane, this little kid was 10 years old and about to die of cancer. I mean, you can't put it any better than that. The kid was about to die of cancer. Was it his spleen, his kidney? Would you remind me?
His lungs, right? He had one of the kidneys removed. He had 4th stage cancer. He had part of his pancreas removed, if I'm remembering, a 16-pound tumor. That's, you know, I mean, he was 10 and 11 years old. This period that they're testifying about now was in 2003 when he was a little bit older and recovered, you know, recovered enough to go around and play around Neverland Ranch.
I just find it very difficult to believe a child that age could be so Machiavellian, that could have the cunning and the cleverness to try to get things out of people. I mean, this is making him an Eddie Haskell to the nth degree. You know, just, I find that hard to believe out of a little kid.
You know, the last witness when I was in the courtroom is Vic Alvarez. He is a longtime detective, very tough cookie. He said he went out and interviewed some of the people that the defense has put on, specifically Julio Avila, and he tried also to interview Chris Tucker. But Julio Avila is a man who runs the rides out at Neverland, still works there. And he said, you know, when I talked to him, I asked him if he maybe had this family mixed up with another family that came from New Jersey, the Casio family. And he seemed to indicate that maybe he did. Maybe he got the Doe family mixed up with this other family, and maybe it was them that was misbehaving so badly. And he also said that, he said the boys crash carts, but all the kids generally drive recklessly out here at Neverland. Basically, kids are allowed to roam free and do whatever they want. They pretty much run amok. Detective Alvarez asked, and he said, yes, all of them pretty much run amok out here. And that's been a theme over and over again, Nancy. So I'm not sure by underscoring that these boys were unruly at Neverland gets you much, because apparently everybody was.
So, Diane, you said that there were 2 rebuttal witnesses today?
No, actually there were 4. This Shane Meredith, who used to be the security guard, Jesus Salas, Vic Alvarez, and there was one more, Nancy, and I'm sorry. Oh, yeah, I remember who it was. It was the DA investigator, Mr. Rooney. He said when they went into Neverland, when they raided, they went in to try to find the logs and the security information in the security shack about the Doe family, and all of it was gone.
Whew. Okay, Diane, tell me how the jury is responding.
You know, there was an interesting moment. I was sitting next to Jim Hammer, who used to be a prosecutor up in San Francisco, the dog mauling case. Yeah. He is here.
He's a good lawyer.
There was a really nice man, too, and I turned to him for expert advice on California law. And Tom Mesereau said to this Jesus Salas, Mr. Salas, have you ever been intoxicated in your own house? Yes. He said, have your children been around? And he said, oh, yes. You know, like, yeah, of course. Where else would I go? And everybody in the room sort of tittered, except for the jury. And Jim Hammer and I spoke about that. We were watching them, and they were sort of shaking their heads like, you know, this isn't funny. And they were taking lots of notes on this. This is the rebuttal case. They got to hear the words today. The defense rests. You'd think that these people would like sit back and say, okay, what else have you got? Let's hurry this up. They are intently still taking notes on every single witness.
You know, Diane, I think I may have had the same reaction. I'm starting to feel like the odd person out. I never, growing up, I never saw my father drunk. I never even saw my father drinking, for Pete's sake. I tried to get out of going to church one Sunday, and my mom told me she was putting me in an industrial home for girls to learn a trade. Okay, so
you came from a much more pious household than I, but I get your drift.
It's not really something to laugh at for little children to see their dad drunk. I mean, that's what he said, intoxicated. I don't mean having a glass of wine with dinner. I mean, it just seems like everything's out of proportion. When will that happen? What about jury charges? I find it hard to believe Mesereau's going to take it laying down. I'd be surprised if he doesn't try to get the last word in with a rebuttal.
Well, I don't know about that.
Well, that's a live shot, Diane. Yes, this is Jackson leaving the courthouse today, right now.
Yeah, he looks particularly pale today and very, very thin. I noticed his shoulder blades are sticking out of the back of his jackets, and he's just like a skeleton now. But to answer your question, yeah, we expect the rebuttal case for the state to go on all day tomorrow. There was a key ruling today that Salas could come back and testify, that Blanca Francia, remember the maid, and her son, her 24-year-old pastor son, youth pastor son, she is expected to come back here. And a new witness that this jury has not heard from, her name is Charlie Michaels, and she was a security guard in '93, '94, way back when I interviewed her, and she told me about sexually inappropriate behavior between Michael Jackson and Wade Robson. Now remember,
children.
Yes, I think that is significant that they're not laughing, and it's not a laughing matter. I never saw my parents drinking either. I think most of America doesn't see their parents drinking, and it isn't a laughing matter. I just want to say one quick thing to what Daniel said. I think you're attributing adult thinking and motivations to a child. I don't think a child can be that much of a huckster. They just don't know how, and in a children's world, if you give them something they like, they're going to ask for more. My dog does that. I give him a cookie, he wants another one. It's a natural response for a youthful mind to want more. I don't think the kid has the ability to be a huckster, particularly when he's ill. That's just, it doesn't make sense to me.
Diane, update.
Yes, I do have an update from Savannah Guthrie, who's been in the courtroom. She says that the state is now, this goes to your rebuttal question, the state is asking the judge to show jurors the original video of the interview that the officers did with John Doe, the young boy at the center of the case. The judge says he will review the DVD tonight and he'll rule tomorrow. The defense says that if that is admitted, then they want to be able to call this young accuser back for a rebuttal. And Savannah says this is not entirely clear, but it sounds as if Mr. Snedden wants Mark Garrigus to come back as one of his rebuttal witnesses. Interesting.
And you really think we're going to be done on Tuesday?
Well, maybe not. Maybe
you know
what? I'm thinking Friday a little bit.
You know what I'm thinking, Diane? That the reason the prosecution wants to bring in this video of the little boy's first statement to police is because the defense suggested to the jury that he had given all of these inconsistent statements, and if they can actually show that video to police, that will show whether there were or were not inconsistencies in the boy's comments.
Right, right. And I think, too, it's been said here that this family, Mesereau has said, well, you know, they went running to police and they had this story and they were eager to tell it because if they get a conviction here, it's easier for them to have a civil case later for millions of dollars. And I think the state wants to prove, because they've said this outside the presence of the jury, that this is a family that they had to coax to come in. They had gotten the report from the psychologist, and then now they wanted to talk to the family. It took them 3 weeks to get the family to come in and actually first have a conversation with officers, and that may be the tape that they want to show today.
Diane Diamond, Ann Bremner.
Hello again. I'm Amanda Grove with the latest from the Court TV News Center. The defense rested its case with Chris Tucker yesterday, testifying that the accuser's mother sometimes acted possessed and the accuser himself could be cunning. Today, the prosecution rebuttal case continues, and joining us now live from outside the Santa Maria courthouse is Court TV's chief investigative editor, Diane Diamond. Hello, Diane. Will the jury get to hear from the accuser again? What do you think in this rebuttal?
Well, part of what the prosecution wants to do is bring in the original, a DVD copy of the original police interview with the young boy whose allegations have all brought us here to this place. Now, the minute that they said that, the defense said, well, look, if they're going to bring in this hour-long original interview with the police, then we have the right to cross-examine the accuser, and we want him to come back here to court. That was a very risky strategy, I think, because if the judge allows it, then it gives the jury a last look at this 15-year-old boy. So the judge said that he would take the DVD home overnight, take a look at it, and make a ruling this morning as to whether or not we can see that original police report.
Diane, talk about evidence concerning phone records and emails involving Mark Garagos, if you will, please.
Yeah, I think that that's part of what the prosecution rebuttal case will be all about. We all know that Mark Garagos has been here not once but twice to testify, and in effect he said he really didn't have a lot of contact with the unindicted co-conspirators. He said he never spoke to Vinny Amin, for example, that he had minimal contact with Frederick Mark Schaffel, etc. So I think because the state just recently won the right to open up Mark Garagos's telephone records, I think that that will be part of the state's case, that they will say, you know, he said he had no contact, but here are the records from the phones, and we may even see some email messages between the unindicteds themselves and maybe even with Mark Garagos.
And tell us about the testimony of Jesus Salas.
Oh, Jesus Salas was very interesting. We had seen him here in the case in chief. Now he was back during the rebuttal case. He used to be the house manager at Neverland, and he came in here yesterday. There he is right there. He came in here yesterday to say, to actually rebut some testimony that's been here about some money having been stolen from his office drawer by the Doe boys, John and James Doe. He said that never happened. And then they started to ask him about whether or not, as the house manager, he needed to know everything that was going on, how often Michael Jackson appeared to be intoxicated. He said, well, toward the end, in February and March 2003, this really crucial period we've been talking about, he said he was intoxicated a lot. He was pressed on that. What do you mean a lot? And he said, well, 4 or more times a week. And he said it got to the point where I was worried about the safety of his own children. Now, he also testified about where the James and John Doe, the Doe brothers, slept when they were at Neverland. He said 90% of the time they slept in Michael Jackson's private bedroom suite. So, you know, you do the math, Amanda. I'm sure the jury was doing the math, too. They slept with him 90% of the time, and 4 or more times a week. He was so intoxicated that Jesus Salas was worried about the safety of the children around him.
Becomes a little SAT question, okay, if you didn't know how many times a week, if you do this. When can we expect...
X equals Y,
exactly,
right.
How many cookies are left once you put the sugar to the... when can we expect closings in this case, do you think, Diane?
Well, I believe that the state will probably end up today, and I'll tell you, today I have found out is Tom Sneddon's 64th birthday, and I think as a birthday present to himself and to this jury who everybody believes has had it, I mean, they're tired, we're going into the 15th week next week, I believe that they will end the rebuttal case today. Not sure about rebuttal. If there isn't one, the closing arguments will start on Tuesday, right after Memorial Day.
Amazing that we're almost there, Diane. I know it's amazing to you who've lived with it for so long.
I see light at the end of the tunnel.
Yes, you do. Diane Diamond, thanks so much, reporting live from Santa Maria, California. And everyone, stay tuned to Court TV. We're going to continue to have live updates from outside the courthouse. We're also going to have specials on the Jackson trial throughout the day, 12:30 to 3. Hello Hello again, I'm Amanda Grove with the latest from the Court TV News Center. Both sides have rested in the Michael Jackson child molestation trial in California, but prosecutors hope to have the jury see the accuser again on videotape. Joining us now live from outside the Santa Maria Courthouse to explain all this, Court TV correspondent Savannah Guthrie. Savannah, hi. Before we get to the rebuttal case, we just want to let our viewers know that this is videotape of Michael Jackson arriving just moments ago. I always do that to you just before I start asking you a question, but it's just the time of the day where we can show people that live picture. Now, Savannah, tell us what we can expect today.
Well, first things first, right, Amanda? We have to establish that Michael Jackson is here, and then we can go forward with the day. It's in the state's rebuttal case right now. We do have a few witnesses scheduled for today, although the state indicates it will rest by the end of today. I think the big issue that's looming out there this morning is whether or not the prosecutors are going to be able to show this videotape. It's a videotaped interview with the accuser in July of 2003. This is where he reveals that Michael Jackson has molested him. And the prosecutors have said they want to bring this on because the defense's allegations all throughout their case has been that this was a scripted story. This is a rehearsed story. Whatever's in this videotape, the prosecutors think that will put that assertion to bed. One thing we do know is that this videotape seems to have the accuser in more of an emotional light. He seems to have more of an affect than he did on the stand. That's the indication from the police sergeant who did the interview, because he's come and testified that the accuser was very emotional on this tape. That's why the prosecutors want to play it. The judge is considering it. He looked at the tape last night. I think this morning that'll be the first order of business. He'll issue a ruling on that. I don't have to tell you that the defense does not want this video to come in, and they've basically told the judge, look, if you let this video in, we won't be able to cross-examine a videotape, so we want the accuser on call for our rebuttal. We want to bring him back in so that we have our right to cross-examine witnesses is not hindered at all. So the judge is sort of facing that. Should he reopen this can of worms? Should he allow the prosecution to play this video, or is it too little too late and they should have done it in their case in chief?
And what about Chris Tucker? Tell me where we stand with him.
Well, Chris Tucker was the 50th and final witness for the defense. If there's no rebuttal, he is the last word of the defense case. And on direct, he had some pretty powerful things to say for the defense. One thing that really sticks out in my mind is his description of the accuser. He said he was cunning and smart, and he suggested that the boy was manipulative, essentially using his cancer to curry sympathy and more gifts from Chris Tucker. Chris Tucker said the accuser would say things like, oh, Chris, can I have this? Can I have that? I'm not feeling very well. Come on. You know, kind of using his illness. Chris Tucker also said on direct that it was the accuser and his family that were looking for Michael Jackson right after the Bashir documentary aired, that they're the ones who suggested this trip to Miami. The prosecutors have suggested it was Michael Jackson who sought out the family, that he made a call to them on February 5th, 2003 and beckoned them to Miami. It's very important, this distinction, because of course that's one of the few acts that directly involves Michael Jackson, that they can directly tie Michael Jackson to in this alleged conspiracy. On cross, Chris Tucker was a totally different witness. Many court observers described him as evasive. At least one person thought he was outright lying. He seemed to have a complete memory lapse. Couldn't remember, when his brother's wedding was. Couldn't remember whether he had bought his girlfriend a Mercedes SUV and when that was, and whether the Doe children had gone with him. He just seemed to be not wanting to help the prosecution one bit, which is understandable, but for the prosecution, it helped for them to show that this is a witness who clearly has a bias.
Exactly. These credibility and bias issues are so key in this case, who jurors decide they believe. Now, closings, we understand, are now expected on Tuesday, and then the jury will get the case. If Jackson is convicted, what kind of prison time are we talking about for which counts?
Well, it's extremely complicated. This is a 10-count indictment, and the sentencing schemes in California are very complex. But let me bottom line it for you. If Jackson were to be convicted of all counts, most legal experts think the sentence would be around 19 years. That's a big if. It's if he's given the maximum sentence possible under all of the counts, that's what he would get. But as I say, you got a lot of moving parts here, and I think that the judge has wide latitude in sentencing Jackson if he is convicted. So expect, vigorous arguments from both sides if we get to that. A little premature to be talking about that, though. We haven't even gotten to closing arguments quite yet.
I know, Savannah. One day at a time, one step at a time. Thanks so much for that report, Savannah Guthrie, of course, reporting live from Santa Maria, California. And stay tuned to Court TV. We're going to continue to have live updates from outside the courthouse. We're also going
than 60 days, Michael Jackson has made this walk from his SUV into the Santa Maria courthouse. But his days at the courthouse are dwindling. Today, the prosecution continues its rebuttal case, and by next week, jurors could get the case. Question is, will they hear from the accuser one last time? Welcome back to Trial Heat and our special report on Michael Jackson's case. I'm Jamie Flood. We're going to go before they end their rebuttal case, prosecutors want to introduce a videotaped interview of the accuser. And joining us now with the latest. I'm so anxious to get to Savannah Guthrie. I stopped reading what I was supposed to read. I just want to get out there and get the news. Savannah, tell us what's the latest with this videotape of the accuser, whether the judge is going to let it in, and whether or not it will mean something for the defense and how they can respond to it.
Boy, I have a lot to tell you, Jamie, so let's start with the video. I'm excited, too. The judge is going to let this video be played, although he doesn't want the full hour to be played. He said he thinks the prosecutors could cut the fat and basically get it down to a half hour. So that's what's being done behind closed doors right now with some of the lawyers. They're trying to agree on a half hour. But the bottom line is this video, that first interview that the accuser did with the police in July of 2003, will come before this jury. So this jury will hear again from the accuser before this case is over. To the second part of your question, you bet. The defense has now said, all right, fine, Judge, because of that ruling, we would like the accuser, the accuser's mother, Larry Feldman, and Dr. Stanley Katz, the psychologist who interviewed the accuser, all to be ready to go for Sir Rebuttal. Can you say closing arguments may not be on Tuesday as we all expected? On the other hand, I think there's some gamesmanship going on here. I think everybody's calling everybody else's bluff about will they really call these people back to the stand, but that is the state of the state right now. This case may have just gotten a little bit longer.
So, Savannah, Sir Rebuttal, of course, rebuttal by the defense to the rebuttal by the prosecution. But did the judge rule on the question of whether defense attorneys could recall these witnesses to respond to a piece of videotape, or has he not yet ruled on that part of this issue?
Well, not explicitly, but evidently he's fully prepared to let them call these people. I mean, we were talking phone numbers this morning. The defense said, we want to call these 4 people. And the judge said, okay, you need to get the phone numbers from the prosecution. The prosecution said, hey, you know, we actually tried to call Larry Feldman to give him a heads up, and he is in South Africa. We'll call the other. I mean, it seems like this train is leaving the station, and everybody's ready to have these 4 people come back to the stand.
Okay, now, Savannah, that's a big piece of rather explosive news out of Santa Maria, but you know, there's other big explosive news, maybe even bigger. Let's talk about the boy we have known for so long as the 1993 accuser. What's going on? I thought we were done with 1108 stuff in this case.
Well, let me tell you what the prosecution tried to do this morning. They asked the judge if they could introduce the photographs of Jackson's genitals from the 1993 investigation. As you know, Jordy Chandler, the 93 accuser, reportedly described Jackson's genitals in some detail, described a particular blemish on them, and the pictures evidently corroborated this. The prosecution wanted to bring this into evidence. The judge said, no, it's not coming in. Needless to say, the defense had objected vociferously, and they won the day on that one. So we will not be seeing those photographs displayed on the giant jumbotron inside the courtroom.
Well, and I bet you're pretty happy about that, Savannah.
I gotta tell you, Jamie, I'm relieved.
I think everybody in that courtroom was holding their breath, hoping that Judge Melville would rule, whatever your point of view in the case, on this issue the way he did. But let me ask this, Savannah, is this the same imagery that Michael Jackson talks about in that now very famous tape he made about having his privates photographed by authorities? Is that the same exact piece of evidence that's at issue?
It is. It is. I mean, just imagine for a minute, these photographs are sitting in some evidence locker for over 10 years, and the prosecution wants to dust them off and bring them out. This is, we all remember when Jackson went on and made this videotape statement about this humiliating search warrant that was served on him, the so-called body search warrant. Yes, these photographs were taken. They're obviously extremely explicit. Many people have long said that that was one of the strongest elements of the prosecution's case against Jackson, and that that was one of the reasons that led the Jackson Jackson team to settle the case for what we know was more than $20 million. So yeah, this is obviously explosive evidence. The judge knows how explosive it is, knows how inflammatory it is. I don't think he was about to let it in.
Was his ruling based, if he even said what the basis was, on the more prejudicial than probative theory, or did he say it's not really relevant enough because it's not even about this accuser, and we've had enough of that 1108 stuff?
A little bit of both. I guess what the prosecution had argued in their papers, which, by the way, we don't see until days later, but the prosecution had argued that this rebuts something that was in the defense case where one of the witnesses said that Michael Jackson was shy and didn't like to undress in front of people, and they had argued that somehow this would rebut that. And so that's how the judge, he sort of hung his ruling on that, saying, you know, even if that was an issue in the defense case, and I'm not sure it was, it's really a collateral issue. And because of the extremely prejudicial and inflammatory nature of this evidence, you know, it doesn't make any sense for me to let it in.
Wow, well, a lot going on out there. Motion practice usually isn't very interesting, but today even the motions in the Jackson case are fascinating. Now, we are joined also by someone else who had the privilege of being in that courtroom to hear these explosive arguments being made, one cutting one way for the defense, the other for the prosecution. Jim Murray, now senior correspondent with Inside Edition, joins us, and let's talk then about the most recent one Savannah addressed first, this issue of whether or not these very graphic, explicit photographs of Michael Jackson's genitalia would come into court. I know you were holding your breath along with everyone else. The judge has said it's not coming in, but did he make a mistake? Is it relevant in the case? Should it be shown to the jury to try and corroborate Jordy Chandler, the 93 accuser's argument that he was molested?
Well, hi, Jamie. The judge was very specific on 2 points. First, he said this is extremely prejudicial, and he did say more prejudicial than probative, but he also went directly to another issue, and that's the fact that in the 1108 witnesses, Jordy Chandler was not among them. So it seemed unfair, in the judge's view, to bring in corroborative evidence for a witness who never testified and was not subject to cross-examination. He thought that that seemed patently unfair to the defense, and I think that on that basis, it was probably a smart thing to exclude this evidence. If Jordan Chandler had come in and this would support his claims, prior consistent statement, whatever you want, I think that at least they would have had a stronger argument. But the fact is, the judge made it very clear that Jordan Chandler has chosen not to testify, so it's just unfair to the defense. I think the defense, and frankly everyone in the courtroom, was holding their breath because this judge tends to rule in favor of a number of these prosecution motions, and this came right on the heels of him allowing in the videotape when we weren't sure how it was going to go, but I think he made the right ruling.
But Jim, even though the 1993 accuser Jordy Chandler didn't take the stand, there was certainly testimony about that alleged incident.
There was, but you know that, let's just look at this on a realistic level. If you bring in these photos and you bring in the description of Michael Jackson's genitals, I think that it is so extremely prejudicial. 1108 evidence is prejudicial anyway.
With a lot of the telephone work in this case. Just recently, the state won the right to open up Mark Garrigas's telephone records because he came here and testified that he really didn't know a lot about what his private detective, specifics about what his private detective was doing on behalf of Michael Jackson, and that he really did not have a very extensive contact with any of the unindicted co-conspirators in this case. Let me just read you a quick update from the courtroom. This just read to the jury. The crucial time period here is February and March 2003, about the time they're trying to get the family to do the rebuttal video and trying to get them to agree to go to Brazil. Here we go. Let's see. A phone chart from February 12th shows that Mr. Garrigas spoke to his private detective, Bradley Miller, twice, and to unindicted co-conspirator Frank Cassio Tyson 3 times. Also on that same day, he had a 3-way call with Bradley Miller and Frederick Mark Schaffel, another unindicted co-conspirator. On February 19th, he spoke to Miller 3 times, and he had another 3-way with Miller and Schaffel. Schaffel doing the rebuttal video. On February 20th, the day that it was taped, Mr. Garrigas spoke to Brad Miller twice and to Mark Schaffel once. The next day, he spoke to Brad 4 times and once to Schaffel.
This is a live shot, if I could just interrupt you for 1 second, Diane, of Michael Jackson leaving the courtroom today. There's Tom Mesereau to his left. And he's wearing a sort of a striped vest today. Interesting. All right, Diane, please go on with that important information.
Yeah, beautiful fabric on that vest. One more. On February 22nd, Mark Garrigus spoke to Mark Frederick Schaffel, 2 Marks there, one time, and he spoke to his private detective 10 times on that day. Now, you know, to be fair, maybe he was talking to Bradley Miller about some other case, but I would think front and center for him would have been the Michael Jackson case at that point.
Really? You think Bradley Miller was involved in the Scott Peterson case? I think not. I think it was about this case, and that's important information, Diane. But Diane, I want to focus in with some laser-like attention to some information that I thought was very important today. Now, I thought, Diane, that the most important bombshell testimony for the defense during their case was the paralegal who said that the accuser's mother admitted to her that she lied in the JCPenney's case, that the bruises that were on her that she said were caused by JCPenney security guards were in fact caused by her own husband beating her. Now, I was always amazed that that paralegal admitted that she never told her bosses about that. She kept a good relationship with the accuser's mom for a period after that. How a paralegal would not go to the attorneys that she's working for and talk about that boggles my mind, because I always had a very close relationship with my paralegals. They would have been in my office in about 10 seconds if they got any information like that. Well, the grandmother of the accuser took the stand today to respond to that. What did she have to say, Diane?
Well, the paralegal said she admitted to me that the bruises weren't done by the JCPenney guards, but rather by her husband beating her in front of her children right after the JCPenney incident. Well, guess what? The mom and dad were put in jail right after this incident. They were not home. They were not with their children. Grandma Doe had taken the children and had them at least overnight, if not for a couple of days. And so we heard from the jail that said she got out about 1 o'clock in the morning, and right after that she went right to the emergency room to be tended to for these bruises on her body. So there was no time for this woman to go home, have her husband beat her in front of her children, as his paralegal said that she said. So that there was a lot of rebuttal to various different bits of information today, but that I found really interesting.
What was the jury's reaction to that testimony, Diane?
Well, you know, they're very somber. I suppose, like all of us, they're getting a little weary, but they're paying close attention. They were paying very close attention to the mother's first attorney, who came in and said, Mark Garrigus said that, you know, I didn't write him letters and tell him we wanted their passports and visas back. He brought this stack of letters, and they were very attentive to that, too.
Okay.
This is about the time you'd think they'd kind of slow down in their attention span, but I don't see it.
I want to get to that Bill Dickerman testimony in just a moment, but Jeff Mandel, this is enormously significant to me, and I'll tell you why. Because the defense has this bombshell witness, a paralegal, who says the accuser's mother admitted to me that she faked bruises in a lawsuit, and she got the children to go along with this story. And in fact, the children saw her being beaten by their own father, and they lied and she lied to get money. That is the worst thing that anyone has said in this case about the accuser's mother, in a case replete with insults to this woman. If that's not true, I mean, if it's empirically impossible because they're in separate jail cells.
To see, however, cross-examination. Why then did the prosecution want to, in a sense, bring him back here through the showing of this videotape of his interview?
Well, I think they want the jury to get one last look at this accuser before they head back into that deliberation room, remind them of what this case is all about. And the other aspect of this is everything I've been led to believe about this video is that it shows an accuser who's much more emotional as he describes the alleged molestation. You know, during his testimony on the stand, his affect was mostly flat. He didn't become upset. You know, he relayed the molestation, you know, and he just sort of set it out there. He wasn't like he was overcome by emotion, in stark contrast, of course, to the maid's son who testified, who's now an adult and who became quite upset as he described alleged molestation. So I think that the prosecutors hope this tape will pack an emotional punch for them right near at the end of the case.
Savannah, as you know, generally speaking, if a witness is going to come on and testify live and in person in a courtroom, generally speaking, unless there's some certain circumstances that exist, the side that calls them doesn't get to also throw in a previous interview, so as they're doing here, or a previous statement that they gave. What's the legal basis that the prosecution was claiming for why they should be able to, even though the jury has already seen and heard the accuser, now have the jury, in a sense, see him and hear him again?
Well, what they told the judge was, look, all through the defense case, frankly, all through the case in general, the defense has said that this boy was scripted, that he was rehearsed, that he was coached, and they think that this videotaped interview will show that the boy was none of those things. So that's why they argue that it should come in rebuttal.
What, Savannah, was the defense's best argument against the tape coming in?
Well, obviously, they aren't able to cross-examine a tape. I think that was their strongest argument. Look, you can't bring this tape in and then we don't get to ask questions. You know, how can we cross-examine? That violates our constitutional rights to confront and cross-examine witnesses. And for that reason, the defense has said, we want the accuser himself to be on call so we can bring him back and essentially cross-examine him as our own witness. And the judge said, fine. But, you know, I think there's a little gamesmanship going on here. It'll be very interesting to see if the defense really does that. They've also said they want to call back the accuser's mother, Larry Feldman, the family's their attorney. He doesn't represent them anymore, and Dr. Stanley Katz, the psychologist who first interviewed the boy. So we'll see if any of those people come and testify.
Savannah, let me just take you back for a second to some of what the judge decided here, because I think it is fairly interesting and fairly different from what you've seen in other courtrooms. But again, that's sort of been the case here from the very beginning. In terms of this videotape, did the judge put any restrictions or limitations on what the jurors are going to see?
Well, this is really interesting. The judge said, okay, I'm going to let the video in, but I don't think you need to play the full hour. I think you could get it down to a half hour. But he specifically said, I'm not ordering you to do that. I'm suggesting it. And the prosecutor said, all right, well, we'll look at the tape and we'll try to go over with the defense and pick a half hour that we can show. It's interesting because, you know, the judge didn't force them to do it, so I don't know why the prosecutors didn't fight harder on it. But what we're hearing this morning is that the defense now wants the full hour. They don't want it to be edited. And so the latest information I have is that the full hour of the interview will be played, with the exception of 2 or 3 minutes that the prosecution said is a little prejudicial and inflammatory against the defendant, and they're not even trying to get that part of it in. So I think we might just see this whole hour-long interview.
So, Jamie, if put you inside the courtroom here as a defense attorney, now, it sounds...
Today, it's 2 classic episodes of Forensic Files, in which Dr. Henry Lee helped solve the unsolvable.
You always can find some clue to reconstruct what happened.
The Forensic Files of Dr. Henry Lee, Tuesdays starting at 9 on Court TV.
Forced to submit to a dehumanizing and humiliating examination by the Santa Barbara County Sheriff. They served a search warrant on me which allowed them to view and photograph my body, including my penis, my buttocks, my lower torso, thighs, and any other area that they wanted.
And that was back in 1993, related to allegations at that point in time. But in this case, prosecutors sought to admit those photographs and some related drawings they claimed were related to that investigation. Let's go back out to Savannah Guthrie. Savannah, a pretty explosive motion yesterday, taking many in that courtroom by surprise. How did the judge rule and why?
The judge said no, and you know, talk about a parental advisory. Listen to his ruling. It's just to hear these words out of Judge Melville's mouth. I mean, here you go. He said, I'm going to deny the request to bring in the evidence of the blemished penis. This is the reason. It's twofold, really. The prejudicial effect would far outweigh the probative value. And secondly, the ability to cross-examine the boy, or the, you know, Mr. Chandler. He's not a boy anymore, and that's definitely not available. So that would be my reasoning for excluding that evidence. You know, the prosecutors had also argued in their papers that because the defense had suggested in its case that Michael Jackson was shy and modest and didn't want to take his shirt off in front of the maid or something along those lines, that this would rebut that, and the judge rejected it for that reason as well.
So even though they claimed, Savannah, that it was about rebutting his shyness and that allegation by defense attorneys, the larger point would have been to support some of what they brought into evidence about what allegedly happened back in 1993. Isn't it argued by prosecutors that there are some unique markings on Mr. Jackson that only someone who'd seen him in the nude, frankly, would be familiar with?
That was exactly their argument, and it's interesting because, as I say, their motion papers talked about this shy, modest rationale for bringing it in, but when they stood up and made the argument, Prosecutor Ron Zonin said, you know, all through the defense, all we've heard about is how innocent, and there's nothing wrong with Michael Jackson sleeping with boys, and this certainly would put that assertion to rest, because this is a boy who apparently is intimately familiar with the details of Michael Jackson's anatomy, that he drew pictures that were spot on when you compared them to the pictures of the genitals. That's what we hear. So, you know, obviously this would have been very powerful evidence to the prosecutors. What I wonder is why they didn't try to do this as part of its packet of 1108 alleged sex offenses evidence. I wonder if they would have had a stronger argument had they tried to bring it in then. And who knows why they didn't. I guess they might have their reasons, could be an oversight.
You know, one reason, Savannah, might be that they thought the argument about cross-examining the 1993 accuser would have been stronger if they brought this in during their case in chief. Maybe they thought if it was coming in to rebut something in the defense case, they had some chance of getting it in. But obviously the judge saw through that if that was their strategy. Let's kick this up to Sandy March, jury consultant. You know, a lot of people, Sandy, think of jury consultants as people who work with defense attorneys only during an opening, during jury selection, and maybe through the open.
Allow this one in. Let's move on, folks, to something else.
Sandy, we're seeing Michael Jackson come to court as he does every day in that black SUV. I mean, I don't know for sure he's in there, but I've been watching now for 50-plus days, and I bet he's coming out. The umbrella's going up. I've seen it every day. He's got the vest. I don't even need to see it to describe it. Sandy, what do you think about Jack's comment that they thought they'd see if it stuck with the judge? A lot of fan presence there. If you can talk over it, we'd appreciate it.
Right. I think Jack's pretty much on target there. I mean, let's take a shot, but you know, I remember being involved in a porno video case and showing the jurors pictures, even just, you know, very brief clips of those types of things, and jurors just don't want to see that stuff. And I think it's somewhat, you know, I think that could be somewhat sympathetic. It could make the jury somewhat sympathetic to Michael Jackson being forced to submit to some of those photographs. Well, so, you know, maybe they took their shot, like Jack said, and tossed it up and see what happens.
And even Jackson's critics talk about how compelling that videotape statement that he released on the internet is. He clearly was humiliated, guilty or not. You can just relate to how horribly humiliating that must have been, to have your private parts photographed in that way, and then to have them displayed in front of your mother and everybody else in that courtroom. I think you're right, there may have been some sympathy engendered. Savannah Guthrie, while we watch Michael Jackson go into that courtroom, is it the case that the prosecution will rest after they show this videotape of the accuser today, later this morning?
Well, that's the plan. My understanding is that Craig Bonner, the police officer who's on the stand right now, will finish up, and then they'll show the videotape, and then it will be done for the prosecutors.
But not necessarily for the defense. We hear, Savannah, let's revisit this issue of the accuser. He is in and about Santa Maria.
Exactly. Now, the defense has said they wanted the accuser to be available, his mother, Jane Doe, to be available, Larry Feldman, the attorney who once represented the family, and also Dr. Stanley Katz, the psychologist who interviewed the boys, who, by the way, the accuser did not reveal the molestation to Dr. Stanley Katz. He did to Sergeant Rabbi. That's the video that they want to play. So the defense wants all those people available, and my latest information is that the accuser is here in Santa Maria, ready to go if the defense calls him.
All right. Well, Michael Jackson just walked into that courtroom.
Inside the California courthouse to explain all of this to us, as she always does for us, is Court TV's Savannah Guthrie. Savannah, good to see you again. Let's start off talking about what they've been doing in the courtroom once they got started. I understand there was some discussion over some legal arguments or issues or strategies or something, but you can fill us in on it.
Mumbo jumbo, right, Jack?
That's the technical term I think they're using.
Yeah, we learned that in law school. You know, it was really a discussion, I think, to make sure everybody was on the same page about why this videotape is coming in. It's not an exception to the hearsay rule. It's not being offered as a prior consistent statement. It's not being offered for the truth of what is in that tape. Rather, the judge said, I'm letting it in because I agree with the prosecution that it will allow the jury to assess the accuser's demeanor in order to rebut the defense's contention that this was a scripted and rehearsed performance. Now, the issue then turned to the rebuttal. As we've been reporting, the defense has said, okay, fine, then we want to call John Doe, we want to call his mother, Jane Doe, Larry Feldman, Dr. Stanley Katz. And I think the judge just wanted to get a sense from the defense where they're going with this. And he said, I'm not going to reopen this trial. I'm not going to let either side basically delve back into the central issues, only to the extent that these your rebuttal witnesses address why this videotape's coming in. So, for example, the defense has said, all right, well, we want to call Dr. Stanley Katz because on this videotape, the accuser says, I haven't told anybody about this, not even my brothers or sisters. And the defense said, well, Dr. Stanley Katz will say that the sister said her brother did tell her about the alleged molestation. Now, the prosecutors actually disagree with that, but that was one of the areas of discussion. Basically, the judge wants to make sure that any rebuttal is very tailored to address why it is that this videotape is coming in, you know, to address what's been done in rebuttal.
Savannah, let's do a quick law school tutorial here, if we might, for our viewers who are probably watching this and saying, well, why didn't the prosecution, when the accuser was on the witness stand in the first place, just say, okay, while you're testifying here, let me just run this tape for the jurors of the statement that you gave to the police when you were interviewed. Explain to us technically why they can't do that at that juncture.
Well, because it would be hearsay. And so, you know, the reason for the hearsay rule is you can't cross-examine a statement that's made outside of the court. Even when it seems a little bit weird, but even when the accuser's right there on the stand. Now, there's an argument that they could have brought it in on redirect, because at that point, the accuser was impeached. His statements were impeached with inconsistent prior statements. And once that's done, the hearsay rules say then you can come back and bring in a prior consistent statement. Well, you know, the prosecutors didn't do that. And when they offered it in its rebuttal case, the prosecution said there's two reasons. One, we think it is a prior consistent statement. And number two, we want to show the accuser's demeanor. And the judge has now, you know, basically elucidated why it was that he's letting it in. It's not for the first reason, it's for the second. He thinks the jury should be able to see the accuser's demeanor.
So, Savannah, now that they've worked through some of the legal issues, do we expect to hear that videotape at any moment? And what are the whereabouts of the young man featured in the tape, the accuser?
Calcium is an 8-ounce glass of milk for strong bones to help prevent osteoporosis. Metamucil capsules plus calcium. Stay regular, stay strong.
Here we see Michael Jackson live. He is leaving the courthouse as we watch in Santa Maria. This is just in time as it is happening. An astounding moment in the courtroom, I have to say. Mr. Jackson now being followed by Mr. Mesereau with the white hair, his usual bodyguards, his family getting into the van. Everyone has rested. The prosecution rested in rebuttal. Michael Jackson's lawyers rest in rebuttal, not putting on any evidence. Certainly astounded me, as I'm sure it astounded you. But I trust the ability of Tom Mesereau that there had to be some reason for doing that. This has to be a strange moment as you watch it here, and I join you, because there's a relief that the evidence is in. That always happens for lawyers. At the same time, there's always that question that the lawyer second guesses himself or herself. The client second guesses, should he have testified, shouldn't he have testified? Is this a moment that they feel good? Is this a moment that they feel bad? Tom Mesereau, of course, as you watch, looking into the car, having said goodbye to Mr. Jackson, shaking hands with Mr. Jackson's bodyguards. This is a trial that they all feel has taken its time, lo, these many weeks, and next week we assume that the closing arguments will begin after the jury instructions are settled upon. Michael Jackson, when he goes in and out of that car every day, you can hear the cheers of his fans who continue to come up and cheer him on as he faces this trial and faces not only this accuser, this young man, but also there have been allegations of accusations from the past going back to about 1993. Diane Dimond just talked about one of the young men who came forward as an adult to say that he had been molested back in those days.
Here you hear again the cheers, and off goes that van. Michael Jackson will not be having a restful Memorial Day, no doubt about it. These are the times when you just really have to think about where your life is, where your liberty is, what the fate of your life is.
Very powerful, by all accounts, powerful piece of videotape, but they chose not to. Now, David, you're a criminal defense attorney. Was this a mistake, or was it a really smooth, mature decision on the part of one of the best trial attorneys in the country, Tom Mesereau?
It was a smooth, mature decision. Tom Mesereau is an excellent cross-examiner, and he made a lot of hay when the complainant and the complainant's mother testified during the state's case. And it's unfortunate because it seems you not only have the prosecutor, but you have Judge Melville, who basically boosters the prosecutor's weak case by putting in all types of things like the prior bad acts. He let them in. He lets in this videotape. He knows that it's idle threats. They're not going to put the accuser back on the stand or the accuser's mother back on the stand. That would be pointless. So unfortunately, yes, you as a defense attorney, you would love to be able to come back and put on additional witnesses, but you know that's what's in the best interest of your client is just to wait for closing and take care of it then.
And Savannah Guthrie, Mr. Mesereau choosing not to be here today, is that correct, for the charging conference? He's preparing his closing argument?
Oh, I'm sorry. Honestly, I didn't hear you. Can you say that again?
Which attorneys have decided to come to court today? I know Michael Jackson's not coming today. Who's there to argue the instructions, and who's home preparing for closing?
You know, they're not here today, and I haven't heard what they're not here yet, so I haven't heard yet whether Mesereau will come, but that would make some sense because traditionally Robert Sanger has done most of the legal arguments, most of the briefings, so this is one of those wonky law things that people do inside the courtroom, and so I think Robert Sanger would be the one who will probably argue the jury instructions. Wouldn't be surprised if Tom Mesereau decided to sit it out and maybe practice his closing argument in front of the mirror, or whatever it is that they do.
I always use the mirror. There's nothing wrong with that. All right, Savannah's going to stay with us. We're going to take a break. Our special report continues with a look back at the prosecution's case. Did the state prove the charges against Michael Jackson? We'll be right back. This half hour, the prosecution's case. Savannah Guthrie, the state made certain charges against Michael Jackson. I guess another way of asking the question is, what did the state promise to prove against the entertainer in its case?
Well, they have the burden of proving a 10-count indictment. You know, it's an interesting case because it's a molestation case, but it's also a conspiracy case. There's one charge of conspiracy accusing Michael Jackson of conspiring to kidnap, extort, and falsely imprison the Doe family. Then there are 4 counts of molestation, lewd conduct with a minor. There's another count of attempt to commit lewd conduct. And then there are 4 counts of administering an intoxicating agent. This is the allegation that Michael Jackson gave alcohol to the young boy for the purpose of committing a felony, which of course would be the felony of molestation.
And of course the molestation being the most serious of the charges, both in terms of the underlying facts alleged as well as time to be served if convicted. So in the end, Savannah, it really does come down to the accuser's allegations. Of course, he testified as well as his mother and his siblings, but the real question for this jury on those most serious charges will be whether or not they believed the accuser. What did he tell the jury, and how was it received, Savannah?
Well, yes, he testified early in the case, and you're right, the case more or less turns on whether or not they believe the accuser. And the story he told is one of Michael Jackson introducing the subject of masturbation and then offering to show the boy how to do it. We have a report now about the accuser's direct testimony. Let's listen.
For the first time since the allegations of child molestation arose, Michael Jackson and his accuser met face-to-face in a court of law. Jackson's accuser took the stand for 4 days of testimony and told the jury about his friendship with the King of Pop. Among the many things he recounted was how they looked at pornography together. He testified, Frank started doing stuff on the internet, and then they started looking up adult material sites. Where was Mr. Jackson there? Answer, yeah. Question, Mr. Jackson was involved in that? Answer, yes. There was this girl with her shirt up, and Michael says, like it was all quiet and stuff, and Michael was like, got milk? And we started laughing because he said that. The boy also testified about how Jackson gave him alcohol when they were together. Question, after Mr. Jackson handed you the can and he told you that it was Jesus juice, what did you do? Answer, I drank a little bit of it and I told him that it tasted ugly. And what did he say? He said that it's okay because it will relax you. Then he spoke about the allegations at the heart of this trial and told the jurors how he says Michael Jackson molested him. Question: at any time while you were at Neverland Ranch, did Mr. Jackson ever touch you inappropriately? Answer: yes. We were under the covers, and I had his pajamas on, and then that's when he put his hand in my pants, and then he started masturbating me. But the boy says it didn't end there. He testified, the same thing happened again. We were laying there, and then he started doing it to me, and then he grabbed my hand in a way to try to do it to him, and I pulled my hand away because I didn't want to do it.
Well, that last part of testimony, of course, is the attempt charge. It forms the basis for the attempt charge. You know, a lot of people who watched the accuser's testimony felt that he came across as pretty genuine, pretty believable on direct, but that his demeanor drastically changed under cross-examination. Let's listen to a little bit more about that.
The case against Michael Jackson could hinge on the credibility of his accuser. And after an intense cross-examination by defense attorney Tom Mesereau, the defense is hoping jurors don't believe the young man's story. Mesereau painted the accuser and his family as money-hungry grifters who consulted an attorney before going to police. Question: you went to 2 lawyers, a psychologist whom Larry Feldman referred you to, before you went to any police officer, right? Answer: yes. Mesereau also asked the accuser about inconsistencies in his story when the boy initially denied any misconduct by Jackson. Question: Dean Alpert looked you in the eye and said, are these allegations that Mr. Jackson sexually abused you true? Answer: uh-huh. And you said they were not true, right? Answer: yeah, I told him Michael didn't do anything to me. Mesereau then questioned the boy's timing of the allegations. Question: what you're telling this jury is that after this investigation starts and after you and your family are questioned, Mr. Jackson supposedly starts touching you inappropriately, right? Answer: yes. Mesereau also addressed allegations the family was imprisoned in Jackson's 2,700-acre ranch. Question: during the period you claim you escaped from Neverland 3 times, do you recall anyone in your family ever complaining to LAPD officer Andrew Lasik that anyone was being mistreated or held against his will? Answer: I don't remember anything happening like that. Mesereau also let jurors know the accuser is no angel. Question: you had some disciplinary problems with Mr. Geralt, right? Answer: I had a lot of disciplinary problems. And Mesereau presented a possible motive, explaining why this young man is making what the defense calls false accusations. Question: you expected Michael Jackson to support you, your mother, your brother, and your sister indefinitely, correct? Answer: no. You wanted to be part of his family, and when you found out you weren't going to be, you got angry. True? Answer: no.
Well, of course, it was a very powerful and fierce cross-examination of this accuser, and that's what makes this last bit of evidence in the rebuttal video, that final video of the accuser's story, so good for the prosecution, because that's the last word, and the jurors don't get to hear the cross again because the defense wasn't able to cross a videotape, Jamie.
Now, just to remind us, Savannah, because it has been a while, how old was the accuser when he claims the molestation occurred, and how old was he when he took the witness stand?
13 when he claims it occurred, and then 15 when he took the witness stand.
All right, so a little closer to manhood, but still a young man, making it difficult to cross-examine him. But Mesereau, it seems, was able to shake him. Wonder whether he alienated the jury at all in doing that. Let's jump over to Bill Bastone. I said earlier, Bill, I opined that the case more or less turns on the testimony of the accuser. So now I'm going to give you an opportunity to give an opinion. Do you agree with that?
100%. I mean, listen, if you're sitting in that jury box and you think that, you know, John Doe is believable, Michael Jackson is going to be convicted of at least 9 of those 10 counts. You know, I mean, the molestation counts are coupled with the provision of intoxicating agent count, and then the other one, the attempted molestation. He speaks to all 9 of those. The conspiracy, well, is really something that hinges on whether you believe the mother or not, and, you know, I'm going to find it hard to believe that anyone believes the mother. But yeah, you buy the kid telling the truth, he's going to be spending 15, 18 years in prison, and there's no doubt about it.
Savannah Guthrie, although the theory of the case might require the jury to find all or nothing for Jackson or the prosecution, they can, as a technical matter, split it up. They could throw away conspiracy and perhaps find on some of the molestation and also convict on alcohol or any variety of any various permutations of these counts, right?
Yeah, I really agree with that. I think there's a principled reason for doing so. For example, the jury could say, well, we believe John Doe, but we don't really believe the brother. Because there are 4 molestation counts, 2 of which were testified to by the accuser. The other 2 were testified to by his brother, and the accuser doesn't even remember them. So let's say the jurors think we don't really believe the brother. They could throw out those molestation counts. As far as the alcohol, if they didn't believe the brother, if they didn't believe the accuser on that, they could throw those out, but still do the 2 molestation charges. They could get rid of the conspiracy, not believe any of that. You know, I think there's an endless combination of charges, of convictions that would make some sense in terms of the evidence.
David Foley, you know, this is kind of an unfair question to ask, given what Savannah just explained, but in the end, did they make their case against Michael Jackson or not?
No, they didn't. They overcharged this thing, and I don't think you're going to have a split verdict on this. Is that, for example, every person who has been sexually assaulted who's 13 years old, their first stop is always to a civil lawyer. It's never to the police. That's absolutely preposterous. It's ridiculous. And the idea of this conspiracy, which they didn't have to charge, they didn't have to bring the mother in on all this, is that this is either going to go all one way or all the other way. You're either going to buy the farm or you're not on this case, and it's all connected to the mother. So it's going to be a not guilty.
The predictions start coming in. David Foley says not guilty. Others say it'll be some sort of split verdict. And of course, still others say a conviction close at hand. One big piece of evidence in this case, alleged prior bad acts. We're going to talk about that right after a quick break. While we take this break, you can vote as our 13th juror. Today, our question is about the Jack. We want to know whether you think the state's rebuttal was effective. So far, 81% of you are voting yes, and 19% of you are saying no. Log on to CourtTVs.com, cast your vote, and we'll be right back. Testified about things having nothing to do with this case, but perhaps with a propensity to commit the act charged.
By my count, there were 9 witnesses. Now, there are 7 witnesses who sort of had a story to tell independently about something that allegedly happened, prior sex offenses evidence, and then 2 witnesses who were called more or less to corroborate what some of those other 1108 witnesses had to say. But the short answer is 9.
And of course, 1108 is the California, rather unique California law that allows these kinds of acts in. Most states do not allow alleged prior bad acts to come in, especially where a defendant chooses not to testify. Bill Bastone, I asked you earlier whether you agreed about the importance of the accuser's testimony, and of course we agreed, as we so often do, but I'm going to throw a little monkey wrench in. What if the jury believes, say, the 1990 accuser, the young man, the maid's son, who came in and said that he was molested on a prior occasion, but the jury doesn't believe, or isn't sure it believes, the current accuser? We know the law would require an acquittal in that case, but it confuses matters, doesn't it?
No, I mean, I think that's one of the big problems he faces, is that those things that were alleged to have happened 12, 14, 15 years ago may in fact have been a stronger, you know, the Chandler matter and the one involving the gentleman who now is an auto parts salesman are
otherwise known as the youth counselor.
Yeah, depending on how you need to cast him, but yeah, those you could argue that those were stronger cases than the case in chief, and you wonder whether when they sit down to look at the case and look what John Doe and James Doe said occurred, whether that kind of taint that hovers over the case in chief from the original 2 accusers is something that's going to be very hard for a jury to separate.
So let me ask you, David Foley, how does Mesereau deal with this? I haven't gotten the sense yet, despite all of his brilliance in that courtroom, that he's really taken on this problem of the 1108. I mean, they certainly called their witnesses, and we'll talk about that in our next special, but how does he handle this in his closing argument? That's going to be his last opportunity to try and separate the current accuser and his story from all of these other witnesses, 9 in total, who came forward to talk about stuff that may or may not have happened in the past.
He's going to have to focus it on the present case at hand. That's what they're here to decide, not what happened 10, 15 years ago. If the only way he wants to utilize it to his favor is that the mother, who already took J.C. Penney's for a ride, knew about Michael Jackson and the problems that he had had in the past, and she wanted to make Michael Jackson part of J.C. Penney and get a few dollars out of him.
So I guess he's got a really tall order, even though the law supports a focus on the current accuser in his case. Mesereau's got to somehow separate out all of those prior allegations, and there were a lot of them. Savannah, a separate and interesting point. We saw a very happy Ron Zonin leaving the courthouse on Friday, and then we learned that Ron Zonin will be giving the closing argument, not Mr. Sneddon, the lead prosecutor in that office and on this case. An interesting decision by prosecutors.
It is interesting, especially since DA Tom Sneddon is so associated with this case, and so many people think that he has a personal vendetta against Jackson. If that's the case, it shows a lot of restraint on his part to not give the closing argument in the case. The other reason people are surprised is because actually before the trial, the judge told the lawyers, he who does the opening statement shall do the closing argument as well. Evidently, that rule has been relaxed, and Ron Zonin will deliver the closing. He's a very capable lawyer, very surgical in his questioning. I'm sure he'll deliver a strong closing argument. Goes without saying that Tom Mesereau will as well. It's Ron Zonin who gave the opening statement in the grand jury on this case, so he certainly is familiar with the facts.
Fascinating, and an interesting dynamic must be happening inside the prosecution team. I think it actually...
Tonight, starting at 9, it's 2 back-to-back episodes of Forensic Files. And at 10, it's a full hour of Masterminds.
All right, we're back with our continuing coverage of the Michael Jackson trial. Things wrapping up in Santa Maria. We have a special guest joining us here again today, Flo Anthony. I want to talk to you about what you think could be the possible outcome in this case.
Well, I think definitely he'll be acquitted on conspiracy, and definitely he will be acquitted on the giving the minor wine. They didn't prove either of those. And, you know, I don't feel that he molested anyone. I don't think the prosecution put on a case to show he molested one, but I don't know what's in the mind of those jurors with the child being on the stand saying that he was molested. So, you know, I'm hoping he will be acquitted on that charge, but because they did not prove it, but still the child did sit on the stand and say this.
You're right about that, and there are jurors, there's a possibility that they could believe that this in fact occurred. If that happens, Michael Jackson could be convicted. If he's convicted, he could be facing prison time, and a lot of it. You know him very well in the Jackson family. How do you think he would hold up?
I think that any time you face adversity, you have to do what you have to do, and you would have to hold up. I don't want to even think in terms, though, of him having to be imprisoned. But I think that, as I said at the beginning of this show, he's a much stronger person than people know that he is. He's withstood this. I mean, he may not have been able to eat, but he's never been a big eater. He's withstood this for 62 days. And, you know, this has been a terrible ordeal.
How would any of us hold up, really?
I mean, nobody wants to go to jail, so I mean,
and under this scrutiny and worldwide attention. Let's bring in Trent Copeland, criminal defense attorney. It's a tough job for any defense attorney when you have to prepare your client for the possibility of a guilty verdict, let alone this kind of prison time that he would be looking at. How do you do it?
Well, you know, look, I think going in, Tom Mesereau must have had the conversations. These are real difficult heart-to-heart conversations that you have with the defendant. I think that probably happened very early on. I think it also probably happened again, Kimberly, as this trial progressed, and particularly at the end of the trial when Tom Mesereau had to make the decision as to whether or not he put Michael Jackson on the witness stand. I think it probably resurfaced then when he talked about, you know, the potential for jail time, the potential of this jury not finding Michael Jackson not guilty, but rather convicting him of some or all of these charges. So, you know, it's a difficult conversation to have, but you have it with your client. You tell them that these are the potential options. This is where our exposure is, and you let them know very well that you're in it with them, but these are the potential options, and they're heart-to-heart conversations.
Not an easy conversation. Well, we may have the answer to that question by next week. Will he be convicted or not? All right, Flo Anthony, thank you so much for joining us. Trent Copeland, Bill Fallon, and Brian Weiss, and of course Diane Diamond. Thank you very much. We'll be right back with our 13th juror results.
To you, the lowest rate and fee. Credit problems are no problem at ditech.com. Log on or call 1-800-80-DITECH.
Michael Jackson's case is slowly winding down. Today, jurors are expected to be instructed on the law, and they could get the case later this week. Welcome back to Trial Heat. This is our special report on Michael Jackson's case. I'm Jamie Floyd. Right now, the attorneys are finalizing those instructions inside that Santa Maria courthouse. Joining us now with the latest is Court TV's Savannah Guthrie. Someday out there, huh, Savannah? We're getting close to the end. What's going on right now?
We're getting close, and you can feel it in the air, Jamie. Suddenly, this little media city we have is populated with more and more people. More and more press have come out here, faces I don't necessarily recognize, and a bigger fan presence than ever. A record 200 people came today to try to get into those public seats in the courtroom, so a lot of people turned away. And this is just for the charge conference. Michael Jackson isn't even here today, not yet, although we do expect him midday. Tom Mesereau, we expect to come later in the day. Ron Zonin to come later in the day when the jury is instructed on the law. Tomorrow morning, closing arguments set to begin.
And we expect Mesereau and Zonin will deliver those. Savannah, the argument about jury instructions, though perhaps not the most dramatic moment in a courtroom, can be very, very important to the outcome. And many analysts feel that the most important instructions in this case will surround the so-called 1108 witnesses that go to prior alleged bad acts. Are they still battling that instruction in that courtroom, or has the judge made some decision? And if they're still arguing, what's the issue?
Well, I do believe the defense is likely to ask for a special instruction on this issue, but we haven't heard it yet, and they haven't taken it up yet. They're actually still arguing over the Bashir documentary, whether or not the admissions in there constitute an exception to the hearsay rule, whether they can be offered for the truth of the matter. So pretty esoteric argument going on in there. Yesterday, however, it was agreed, at least for the time being, that the standard pattern instruction, this is the instruction that's in the books and has been approved by the California Supreme Court, will be given unless there are modifications that the judge approves. And let me just read you a little portion of it, because I think this gets to the heart of it, Jamie. It says, if you find that the defendant committed a prior sexual offense, you may, but are not required to, infer that the defendant had a disposition to commit sexual offenses, a line that really turns a whole body of law on its head, and is the reason, of course, why 1108 is so controversial.
And without that instruction, whatever you think about Section 1108, without that instruction, it really has no weight in a courtroom. So it makes sense that the judge would give that, but of course defense attorneys, as you suggest, will argue for special instruction to try and counter it a little bit. Now we're looking ahead to closing arguments beginning perhaps as early as tomorrow. I know there was some speculation they might start today. I think that's reaching a bit. What do we know about limitations the court will place on the attorneys who will be arguing the case?
Well, we've been reporting this morning that the judge has told the attorneys they have 4 hours each to deliver their closing arguments. You know what's interesting, Jamie? Apparently the lawyers just found out yesterday what the time limit was. So imagine sitting there trying to draft your closing argument and not knowing how long you have to give it. But that's our latest information, and that it will start tomorrow morning, which was the DA's preference, and the judge was inclined to go along with that so the DA wouldn't have to split it up over 2 days. So if that's the case, we have about a 5.5-hour court day here in Santa Maria. So that would mean that the prosecution would start tomorrow morning and then probably reserve a portion of their time. The defense would go, continue Friday, and then the state would have whatever it decides to leave of its time, an hour, hour and a half. They would have the last word, which is very common because, of course, the state has the burden of proof. So by my count, the jury gets the case by Friday afternoon.
All right, well, Savannah, we'll stand by. This is an hour-long Jackson special, and we're going to have Savannah Guthrie with us for much of it. But I'm going to take a moment now to introduce two very joins us, and I'm also joined by Angelo McDonald here in my New York studio. And I guess I'm going to start with you, Angelo, because I think the question of instructions, though somewhat dull, is quite fascinating in this case when you talk about the prior bad acts. How important is it? I think Angela makes a very good point that attorneys like to weave in portions of the instructions in their closings. Do we expect instructions to be given at all before closings, partial instructions, full instructions, or will the judge wait until after closing arguments?
Sounds like it's going to be a pre-instruction situation. In fact, today, the plan is for the jury to come in at noon today, be instructed by the judge, and then sent home, and then closing arguments to start tomorrow morning, first thing at 8:30 Pacific time.
All right. Well, that gives me an opportunity then to ask Rabbi Boteach, who has been sort of our spiritual guide through the Jackson case, and we thank you so much for that. As we look toward the end of the case and Michael Jackson and his team can see some light at the end of the tunnel, you've been very concerned throughout the case about the client in the case, Mr. Jackson, and how he might withstand all of this. And you and I speculated that he might not make it this far, but he has. What's your advice to the team in terms of continuing to give him support that he needs through the verdict watch, which I think is perhaps the most stressful time for a defendant, any defendant, but particularly this one in this case?
Well, the real star of this trial clearly is Thomas Mesereau. You know, like with the story of Humpty Dumpty, it's the king's men who have come to his rescue. Yet again, a lawyer has gotten Michael out of a lot of serious trouble. I mean, for me, this case is over. The defense won it, and because Mesereau, he kept Michael under control, and he launched a brilliant defense, shredded the witnesses. And now the question becomes, really, if I were the defense, he might be saying to Michael, look, we're confident about what's going to happen with the jury. Now your life will return to you, and what will you do with it? This is the last chance for them to rescue Michael for himself, for them to impress upon him. This is as serious as it gets, Michael. If you get out of this, this is as close as it gets. You might have gone to jail for the next 20 years. You've got to get your life together. Your life is on a steep downward decline.
Have you heard, Rabbi, reports that there are those in Las Vegas willing to give Michael Jackson a regular gig out there?
Of course.
So that he might be able to make some money and get his life back on track?
Yeah, but Jamie, even if he goes through a spurt of money making over the next year or 2 years because of this he'll have like a comeback victory tour. Michael loves, you know, always being victorious over the endless cast of enemies that he thinks are arrayed against him, because he always thinks that the world is jealous of his success. He used to always say to me, I'm the first black man that had white girls screaming for him. People don't like that. Even if he makes money over the next 2 years, he'll just blow it. He will continue on this sad downward decline. What Michael really needs to do, if he wins this, and I think justice would dictate he should win this, because you can't send a man to jail based on the weak case that was launched against him. If he wins this, the question then becomes, does he go back to being the profligate superstar, this man who's just a strange weirdo, or does he take a year off and say, you know what, I'm going to sell Neverland, I'm going to get rid of all the vestiges of being too much around kids, I'm going to go to a spiritual retreat, I'm going to go for deep psychological counseling, and then launch a comeback?
Well, I got to say, I think you're right about the spiritual retreat, and I'm not a rabbi, but I'm also not going to bet my money that Michael Jackson will be choosing that retreat over the riches of Las Vegas. I'm not sure that I would. We're going to take a quick break. When we come back, we're going to talk about all the evidence the jury never saw in this case, but you will in a moment. In the cameras, Macaulay Culkin was supporting his friend Michael Jackson by testifying for the defense, and he wasn't the only celebrity who made an appearance at the courthouse. Welcome back to our special report on the Michael Jackson case. I'm Jamie Floyd. The witness list looked almost like a list for a Hollywood party. Tonight show host Jay Leno was called to the stand by the defense, and actor Chris Tucker went to bat for his friend Michael Jackson. Comedian George Lopez also took the witness stand, but he testified for the prosecution. But then there were no shows. There were some other names that appeared on the star-studded witness list, people who never showed up. Savannah Guthrie, refresh our recollection. Who were these people that the jury never even knew might come into that courtroom?
Yeah, it's the who's who of who didn't show up at the courthouse. Well, first and foremost, in my mind anyway, is Elizabeth Taylor. She did not come and testify. Neither did Diana Ross, Quincy Jones, Stevie Wonder. Can you imagine if they did a concert after their testimony? I mean, the great musical stars, but they didn't testify, and I think the reason is these were people who would have come and testified as character witnesses on behalf of Michael Jackson, and the defense did not want to go there, didn't want to open the door by introducing good character evidence, because that would allow the prosecutors to ask questions of these witnesses about whether they knew certain information that might affect their opinion of Jackson's good character. Specifically, for example, one of the questions the prosecutors wanted to ask was, did you know that LaToya Jackson, Michael Jackson's sister, claims that he paid $1 million in hush money to make sure a little boy did not go to the authorities with the story. I mean, there was a long list of questions like that that the prosecution was ready to ask, and the defense did not want to open that door.
And you know, even though it's fun to talk about these celebrities, Savannah, it's also a really good primer on the law in this area. Once you bring in good character evidence on behalf of a defendant, the prosecution can then start introducing evidence of bad character, not so good character in this case, and so they made perhaps a smart choice. There was one celebrity, though, Savannah, that the defense did want to call and even showed up, Larry King, but in the end, Larry King was not permitted to testify. Remind us about what happened there and what the jury might have heard if he took the witness stand.
Well, Larry King had some potentially explosive testimony to offer. He was going to say that while he had breakfast with Larry Feldman, who was the lawyer representing the accuser's family, and he said that Larry Feldman told him that he thought that the accuser's mother was a wacko, that's a quote, and that she was in it for money. In many ways, that's a two-sentence summary of the defense theory of the case. However, the judge said this couldn't come into the evidence, and the reason was this. Larry King said that what Larry Feldman told him was just Larry Feldman's opinion. He was not relaying a statement made to Larry Feldman by the accuser's mother. Therefore, it didn't impeach Larry Feldman's testimony. The only way this statement was going to come in, because frankly, it's double hearsay, the only way it was going to come in is if it directly impeached something that Larry Feldman had said on the stand. Well, because it didn't, that's why he wasn't permitted to testify.
And I recall the prosecution very smartly kept Larry Feldman's testimony very, very brief. Let's talk about some other celebrities, if you will, who weren't present. Family members. There was always some hubbub about whether Janet would testify or LaToya would testify. Savannah, those people didn't show up all that much, let alone take the witness stand. Every day, though, we did see Katherine Jackson, I think, almost every single day of the case. And many, many days, Joe Jackson. Here's what Joe Jackson said last night to The Insider.
Every day is difficult to get up there and set up there all that time and listen to all of that stuff that you know is not true.
Were we surprised, Savannah Guthrie, at the limited presence of the Jackson Five and the other Jackson siblings, almost as absent as the parents were present?
Well, you know, it is interesting. Although throughout the trial, you'd see Randy Jackson come in, Jermaine Jackson, Tito. So from time to time, there was a presence, but there wasn't the solid presence that we saw, for example, Katherine Jackson. But let's be fair, there were only 6 seats. So even if the entire Jackson clan wanted to come in and support their brother, there simply would not be room. You know, I should mention, we are hearing that starting maybe as early as today with Jackson's arrival today, but maybe tomorrow as well, that we are going to see an increased presence by Jackson family members, possibly LaToya, Janet, some of the other brothers, to come here and support their brother. That's the word on the street. We'll just have to wait and see. We do expect Jackson to arrive about 11 o'clock Pacific time today, 2 o'clock Eastern.
And you make the point, of course, that there's a limited amount of seating in that courthouse, and there are always questions on the part of a defense team about how much of a presence the defendant's family should have. This is a big family, and you don't want to overwhelm the jury with the power of the celebrity of this family. Rabbi Boteach, you know the family. We just saw a little bit of Joe Jackson talking about how difficult this case has been, but at the same time, Michael Jackson has told Martin Bashir, the first witness for the prosecution in this case in the documentary, of a difficult relationship that he had with his father. Do you know anything about the current state of affairs? Is Michael Jackson somewhat estranged from the family? It certainly seems they've rallied to his support in this case.
You know, the key player to Michael healing himself is actually his father, because Michael said to me many times just how he hungers and thirsts for his father's approval. You see, Michael's father became his manager when Michael was a boy of 5. He never really had a father. He had a father that expected him to produce, and he always wanted his father's love and affection. But that only came through, Michael, you have to sign this contract. And I met Joe Jackson only once. He and Katherine invited me to their home when they thought Michael was really in a lot of trouble, things like prescription drugs, etc. And I said to him, you know, Mr. Jackson, you want me to help your son, but I can't. Only you can. But all you ever talk to me about is Michael's management, his career. He needs a dad. Now, if Joe Jackson wants to finally step up to the plate and become a father to an increasingly a family which is falling to pieces. I mean, let's not forget Janet disgracing herself with that breast incident in the Super Bowl. Let's not forget his other sons who have a history of divorces. I mean, this was a family that was very close-knit. They were dirt poor. They lived in a tiny house in Gary, Indiana. Was their fame and fortune a blessing when you look at what's happened with the family? Joe Jackson should be a man. Stand up and become a man.
And I should throw in that my father actually grew up right down the street from Joe Jackson. Joe Jackson's a contemporary of his, and Gary, Indiana is our hometown, the family's hometown, and indeed the Jacksons were very poor, and Joe Jackson is largely to be credited. I'm up against a break, but I do want to ask you whether you think the prosecution would have attacked in the way Savannah and I have suggested they would have if those character witnesses came in. Gave the defense team cause to pause when deciding whether or not to put their rather eccentric client on the witness stand. Remember this? Early in the case, Michael Jackson came to court well over an hour late and wearing his pajama bottoms. I am not ashamed to tell you that our ratings shot through the roof that day. Everybody wanting to see Michael Jackson in his night attire, and he had back trouble and had to go to the doctor that morning, and the judge in the end did excuse him, but not after a lengthy lecture to Mr. Mesereau, the defense attorney, and to Mr. Jackson. And then yesterday, Michael Jackson's father, Joe Jackson, spoke to the Insider about that incident.
He couldn't go back home and change clothes and go to the courthouse, so he had to go in his pajamas. We didn't care. We'd go in that barefoot at that courthouse. We don't care. We're Jacksons.
Well, they may be Jacksons, but I think if they went into the courthouse barefoot, Judge Melville would have had something to say about it. Rabbi Boteach, Michael Jackson on the witness stand, yes or no?
They never even considered it. That would have been a catastrophe, and Michael would have been ripped to pieces by the prosecution. They would have thrown so many questions about him, about his bizarre behavior, about his relationship with kids. He would have stuttered, he would have fumbled, and he would have gone to jail.
But Rabbi,
they never considered it.
He's an entertainer. He can deliver a few lines on the witness stand, can't he?
Michael, you know, let me try to give you a perspective on this, Jamie. Michael and I sat down to do 30 hours we did taped interviews about what he saw in kids, and it was supposed to be a book about what parents can learn from their children, not how kids need their parents so that the kids will grow up more secure and with greater confidence, but the opposite. That parents, as we get older, we adults, we begin to calcify, we lose our imagination, we become a bit more cynical, we lose our dreams, and exposure to children almost resuscitates us. So I was amazed at Michael's eloquence on the subject of children, and there really is more to his insight into kids than the world knows. It was actually remarkable material. But that was in a free exchange where I was genuinely interested in hearing what he had to say, and I believe that maybe he saw things in kids that the rest of us perhaps were blind to. That would be very different to a court case where they were going to ask him questions like, you know, did you take a shower with boys? And Michael would sit there stuttering, and it would have been a catastrophe. I mean, Michael Jackson is used to doing whatever he wants. This is the first time in his life where he's been compelled to do things that he doesn't want to.
It is certainly, I think, the seminal case of client control, and I don't even know Michael Jackson, but I can tell you as a former criminal defense attorney, this would have been, and Mr. Mesereau deserves kudos for this, a very, very difficult client to tell what to do, and I don't know that Mr. Mesereau has managed to tell him what to do. I know that Angela McDonald agrees with your assessment that in this case it wasn't necessary. Isn't it almost always necessary in child molestation cases to put your client on the stand and have him tell the jury, I did not do this horrible thing?
Well, look, I mean, the rabbi made some great points, and to directly reiterate that, Michael Jackson has two problems. He's unpredictable and he's uncontrollable. And Mesereau has no control over those two things, and that's why he would be destroyed on the witness stand under cross-examination. This type of case, though, you would expect maybe that a defendant would have to get on the stand and try to give the jury some explanation, some reasonable reason why he would be found either in certain compromising positions, why this witness would come on the stand and say certain things about him.
Why he thinks it's normal to share his bed with young children.
Because it's just so inconceivable that someone, you know, that the reasonable juror would believe that you know, nothing happened. That's my feeling on it, that it's going to be very difficult to convince a juror that something didn't happen here.
Always a very tough decision for defense attorneys, and in the end, it's the defendant's choice to make. We are joined now by a very special guest. I'm so happy to testify. The judge did keep out.
This week at 8, only on Court TV.
Welcome back to Both Sides, and this just occurred moments ago in Santa Maria, California, with the Jackson family arriving to show support for Michael Jackson. There we see Joe Jackson and Catherine Jackson arriving again to show the support for their son, who is on trial for some serious charges. Let's go right back outside the courthouse as well and bring in Diane Diamond to let us know. And we see Michael Jackson as well holding the arm of his mother. Diane, do we expect to have more members of the Jackson family arrive?
Well, you know, earlier today we got word that a lot of the Jackson family was coming. LaToya's name was mentioned, Marlon, Tito, Randy, Jermaine, Jackie, a lot of them. I didn't get the name Janet, although I did see it. I heard some people talking about it. I did not confirm that Janet was coming. Now we see that it's not that big at all, but perhaps tomorrow for closings there will be more of the family. That is expected. But I must tell you, there are only 6 seats for the Jackson side in the room. They occupy the 3 in the front row and 3 in the next row back, and that's all she wrote. I mean, they can bring as many people as they want, but they can only get 6 in the courtroom at a time. They do have a special holding room upstairs for Mr. Jackson and a special bathroom that only he gets to use. So, you know, perhaps there's some sort of tag team thing expected tomorrow. They'll bring the whole family, but some will wait upstairs, and then at the 9:45 break they'll switch, and at the 11:30 break they'll switch. We just don't know.
So is there any way that Tom Mesereau can request for the judge to make a special exception to perhaps find some more seats for the family members just for the closing arguments?
You know, sure, he can certainly make that request. Is it going to happen? I would doubt it.
Right.
This judge is very strict about the way his courtroom is run. By the book, by the decorum order. I mean, we're all still on the Rodney Melville diet. You know, no lunch break, 10 minutes. If you want to go stuff a power bar down your mouth, well, you got 10 minutes. And if you have to go to the bathroom, well, you got to pick between the two. So, yeah, I don't think at this late juncture he's going to change his decorum order.
All right, let's bring back in Royce Russell. Royce, what's the upside and the downside of, say, Janet Jackson and Jermaine Jackson and Randy and Tito and Jackie all showing up at the end of this trial? Any impact on this jury?
It may have an initial impact in that jurors might not be listening to what the prosecutor has to say as far as closing argument, and they may be distracted and looking over at the family members. However, overall, I think, you know, most jurors, if they miss something in the beginning, they may request it when they're deliberating. So I don't know if it has a great effect to the point that it really helps Michael, and it's something that defense counsel may request. I think what is interesting about giving the closing argument and what defense counsel has to be conscious of is that, you know, you want to play into the fact that Michael Jackson is not a community predator, because molestation is a very serious crime. And if you can play into the factor and somehow throughout your summation